The Supreme Court is set to hear oral arguments this week in a case that could disenfranchise voters even more than the current Republican redistricting frenzy. The case is just the latest in a series of attacks on the Voting Rights Act, which is known as one of the crown jewels of the civil rights movement. The case, Louisiana versus Calais, challenges a congressional map that Louisiana adopted in 2024 to comply with the Voting Rights Act. That map created 2 majority black districts. Now, it's hard to see because it looks like one, but it's the big purple thing in the middle, out of a total of 6 districts in Louisiana. You can see them too. The 2 majority black districts are the 2nd and the 6th district. The previous map had only 1 majority black district, even though Louisiana's black Louisianans make up 1/3 of the state's population. That's the kind of thing the Voting Rights Act was meant to address. So in 2022, a group of 12 black Louisiana voters came together, went to federal court, and argued that having just 1 majority black district violated Section 2 of the Voting Rights Act. Now, Section 2 is the most powerful remaining provision in the Voting Rights Act because in 2013, in the Supreme Court decision Shelby versus Holder, it swept away the other key provisions of the Voting Rights Act. So Section 2 is essentially the only thing keeping this crucial civil rights law alive. It outlaws election practices that deny or limit voting rights that are based on race. It applies to election practices like racial gerrymandering, ballot access, and voter registration restrictions. Without Section 2, the Voting Rights Act is essentially moot. So the group of black voters in this lawsuit argued that the congressional map with just 1 majority black district limited their voting power. The new map with 2 majority black districts was meant to fix that, 2 out of 6. But a group of self-described non-African American voters is trying to turn this argument on its head, making their own argument that the new map with 2 majority black districts is essentially violating their civil rights and counts as racial discrimination against non-black voters. They claim the map sorts voters primarily by race in violation of the Equal Protection Clause of the 14th Amendment, which says that no state shall, quote, deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the laws, end quote. That essentially guarantees that states will apply laws equally to all people within their jurisdiction. The state of Louisiana and the Trump administration have backed that argument, asking the Supreme Court to declare the 2024 map in Louisiana unconstitutional. If the court rules their way, that would set a precedent, effectively canceling out Section 2 of the Voting Rights Act, signaling that states no longer need to comply with the very provision designed to protect minority voters and ensure that American citizens have fair representation. According to a report by Fair Fight Action and the Black Voters Matter Fund, such a ruling could flip up to 19 congressional seats from blue to red. Democratic representatives in Alabama, South Carolina, Tennessee, and Mississippi could all have their seats eliminated or consolidated. States like Louisiana, Georgia, North Carolina, Texas, and Florida might retain at least 1 Democratic seat, but their Democratic delegations would shrink dramatically. Congress would also become significantly less diverse. The report warns, quote, if legislators cannot consider race to remedy racial discrimination in voting, the Congressional Black Caucus could lose up to 30% of its members, while the Congressional Hispanic Caucus could lose up to 11% of its members, end quote. Think about that. States can't consider race to remedy racial discrimination. How else would you remedy racial discrimination without considering race? The stakes are not lost on the group fighting to preserve the Voting Rights Act in Louisiana. They wrote, quote, removing Section 2's protections in Louisiana will not end discrimination there or lead to a race-blind society, but it may well lead to a severe decrease in minority representation at all levels of government in many parts of the country, end quote. After a quick break, I'll talk to the great Reverend Al Sharpton. He's standing by. Don't go anywhere. Joining me now, my friend, the Reverend Al Sharpton. He's the host of Politics Nation here on MSNBC. He's the president and founder of the National Action Network, and he works a long day, so I'm always appreciative when you're on the show, Rev. I think you have to think about this 2 ways, right? There's the diminishing of black voting power in America that the Voting Rights Act was meant to help. There's also this idea that this is so politically motivated that it could lock in Republican control of the House far longer than that would normally be because of voting power. There's two big problems to this case.
Yes, I think you identified both of them correctly. Let's remember the context of the Voting Rights Act and Section 2 was because blacks had been discriminated against, because there were all kinds of methods used to deny us the right to vote, how many jelly beans in a jar, all kinds of craziness that robbed us of our right to vote. The Voting Rights Act was to remedy that. And to say that you must have race as a factor to be fair because you're remedying you being unfair was how it came into being. So how do you now reverse that or drop that by saying, well, it was all right to be unfair and that everything now is equal when everything is not equal? We still economically where we are not living in all the districts around Louisiana. This is the case we're talking about when you're dealing with mortgage racism and all of that. So it's not like we're equally distributed.
Right.
And it's not like the population is different. And I think that the political side of it, you correctly bring up, Ali, is that it will, in many ways, give the Republicans a majority that would almost be impenetrable over a short period of time. And I think that's the political motive behind it.
And then the other thing to think about, if you're not in Louisiana, is that if this goes the wrong way at the Supreme Court, it will trigger this non-racial, racial redistricting across the nation and will disenfranchise black and brown voters and, frankly, Democratic voters across the nation in some cases.
It will have a ripple effect all over the nation, not only in voting, but it will have, therefore, in other areas. And we already see the Trump administration starting that with DEI, with diversity, equity, and inclusion. What they're really doing is trying to bring us back to pre-1954 America, where what was normalized was separate and unequal. And that's what's at stake here. That is why this decision by this court is vital, because the ripple effect will then go in many other areas. But the most important area of voting would be seriously impaired.
So for a lot of my viewers, they will remember the 2023 Supreme Court decision striking down race-based college admissions. Louisiana argued at the time, reminding justices of their own words. They said eliminating racial discrimination means eliminating all of it. Louisiana argued, quote, there is no safe harbor for racial discrimination the government deems to be good discrimination. The Constitution orders no quarter, relentless enforcement of the belief that our Constitution is colorblind, end quote. That is a largely discredited view. Most people who read the Constitution will understand it may be colorblind because they didn't say it, but it wasn't colorblind.
It wasn't colorblind, and the people writing it were very color conscious and in many cases bigoted themselves. The fact is, and I remember I was in the courtroom, John Lewis, Jesse Jackson, all of us was there for the arguments when they dealt with 4 and 5. The fact of the matter is that you are trying to deal with institutional historic amnesia when they're trying to act like everything started fair and equal. Yeah. And therefore, anything done differently is discrimination. It is not discrimination. It's to correct discrimination.
This is the voting equivalent of getting rid of affirmative action in the colleges. By the way, not just Republican-led states. The Trump administration has also directly attempted to meddle in state election processes throughout all of this. You were talking about this as well. It's all but gutted the Justice Department's Civil Rights Division, which oversees voting rights. It installed Harmeet Dillon, a lawyer with a track record of arguing against voting rights, to lead it. It dropped Biden-era lawsuits that were aimed at restoring the rights of disenfranchised voters. This administration has even sued states over how they vet voters and for not handing over voter registration information. That's a lot, but it's important. It's not just districts. It's all those you made a reference to, counting the jelly beans in a jar, sort of like we're metaphorically bringing the jelly beans back.
We're bringing the jelly beans back, and they're trying to twist the top of the jar tight where we can't open it back up again, which is why the movements that's going on around the country, from No Kings to what we did on Wall Street, becomes important, because it was that kind of activism that got us the Voting Rights Act in the first place. And people need to understand, if they get away with it, with voting rights as they're using blacks in Louisiana as the target, it will ripple into women's right to vote and to trans rights and LGBTQ, on and on and on. Once you start this train rolling back rights, everybody's rights will be crashed and be under the train wheels.
And that's the important part about understanding this particular topic, which is why I'm so glad that you joined us, Rev. Always good to see you. Thank you for being with us. The Reverend Al Sharpton is the host of MSNBC's Politics Nation.
Thank you.
He's the president and founder of the National Action Network.